Well, good evening, everyone. Ward Cassidy, our Executive Director, and me, Tracy Frederick, the Director of Engagement and Strategy at KSBRC, want to welcome you this evening to the November Kansas School Board Resource Center webinar, Above and Beyond, our update on at-risk funding. Our presenter tonight is Mike O'Neill. He gave an outstanding presentation at our KSBRC second annual meeting about a month ago, and it was so popular that school board members requested that Mike go ahead and do this again, provide a little bit more information, kind of the focused information on this at-risk funding, particularly because there will be accountability requirements coming down the road on the horizon for school boards and for school districts. And so want to make sure that you have that information and plenty of time to put those accountability structures in place. Mike is a familiar face to those of you who've attended our webinars before, but for those of you who don't know Mike, he has extensive experience and expertise that he brings to this topic. Mike is an attorney with over 35 years experience of litigation, and he served in the Kansas House of Representatives for 28 years, including 2 terms as the elected Speaker of the House until the end of the 2012 session. Now, following his tenure in the Kansas State House of Representatives, he served as the president and CEO of the Kansas Chamber of Commerce. And since then, he has been leading his own legal consulting and governmental relations firm. So we're excited to have Mike back. He is phenomenal and know that you're going to gain a lot of experience. He has a lot to go through. So we're going to get to Mike very quickly, but want to let you know that during his presentation, if you have a question, there's a Q&A box at the bottom of your screen, and you can put a question in there, and then I will ask that question to Mike. If it has not already been answered in his presentation, at the end of this or the last few minutes of the webinar, we'll ask Mike those questions. Also, this webinar is recorded, and just as we typically do, we will post this webinar with a PowerPoint on our webpage, and then I'll also send out a link to this webinar. So that's where we are, Mike, and we are ready for you to start this outstanding webinar. Thanks so much.
Well, thank you, Tracy. It's a pleasure to be with you all. I hope everybody's having a good evening. I have somewhat of a caveat for tonight's presentation because we're talking about one of my pet peeves, and the news isn't good. And so what I would ask is that you not shoot the messenger. I'm going to try very hard to lay out the things that are very important, both from the standpoint of the Constitution and state statute, and emphasize once again how important local school boards are in delivering these educational services. And so tonight is going to be more about those kids that qualify for at-risk funding and some of the problems that we have encountered and the legislature has encountered. But first, I always need to sort of set the stage for everything. Starts with the Kansas Constitution in the education article that was promulgated and then approved by the voters back in 1963. And everything else flows from that. So we have the constitutional mandate and then a body of statutory law that follows. And we will be talking about some of those statutes here in a little bit. But Article 6, Section 1 of the Kansas Constitution mandates that the legislature shall provide for intellectual, educational, vocational, and scientific improvement by establishing and maintaining public schools, educational institutions, and related activities which may be organized and changed in such manner as may be provided by law. And then Article 6, Section 6 of the Constitution mandates that the legislature shall make suitable provision for finance of the educational interests of the state. So most of you who have been around education for a while know that we've had a couple decades of school finance litigation. And the Kansas Supreme Court interpreted the phrase, the legislature shall make suitable provision for the finance of the educational interests of the state, as a requirement for adequate funding. So after years of litigation, the Supreme Court ruled that the current funding formula, or the current funding formula at the time, and is now ruled that the current formula is adequate and sustainable. It wasn't. They ruled it was inadequate at the time after the legislature passed a number of new laws regarding school finance. The court has held that that funding formula is adequate and sustainable. That case has been dismissed, and we haven't had an issue with funding for quite some time. I'll talk about that in a little bit. The court held that the structure and implementation of the funding formula must be, quote, reasonably calculated such that all students may achieve the goals set forth in KSA 7232-18. You probably know those as the Rose capacities, and these are the goals and aspirations that we hope and expect every child to have when they graduate from public school. The structure is a function that the legislature is responsible for. So think of it in terms of the legislature putting together a funding formula that is equalized such that all schools are fairly funded. And as we know, districts are funded differently based upon different weightings. Some school districts will get more funds for transportation than others. At risk is one of those that we'll talk about in a minute, but it's an equalized formula. But what we need to emphasize is that the implementation part of what the Supreme Court ordered is uniquely the responsibility of local boards of education. And another way of looking at that is the legislature appropriates huge sums of money for schools, but does not tell the schools how they're going to allocate those funds. Because that's a function of local control, and that's uniquely the responsibility of local boards of education. The constitutional provision for the establishment of public schools and the legal requirement that funding be reasonably calculated such that all students may achieve the goal set forth in the Rose capacities applies to all students, not just at-risk students, but every single student. Now, for the last 20 years, we've had a statute called the Needs Assessment Statute. And until recently, we have learned that local school boards were not really even aware that this statute existed. The statute for over 20 years has required local boards to conduct needs assessments of each attendance center, and the information obtained from those assessments must be used by the board when preparing the budget for the district. And unfortunately, we've seen that compliance with this law has been woefully lax, resulting in the need for the legislature to reinforce the law's requirements in several of the preceding legislative sessions. And I can't emphasize this enough, compliance with the needs assessment law is one of the most important functions of local school boards and one of the most important powers of a local board. You're in control of the budget. Article 6, Section 5 of the Kansas Constitution mandates that local public schools, under the general supervision of the State Board of Education, shall be maintained, developed, and operated by local elected boards. And words in the Constitution, words in the statute are important. They mean what they say. The drafters of the education article and the voters of the education article did not read into this: local public schools under the general supervision of the State Board of Education shall be maintained, developed, and operated by local school district administration. That's not their job. That's your job. The superintendent works for you. He or she is your employee. The constitutional mandate is that you are to maintain, develop, and operate the local schools. And they can't be maintained, developed, and operated unless the requirements of the law are taken seriously. While local boards can and do delegate a good deal of administrative duties to the superintendent or district staff, local boards must assume the primary role of ensuring compliance, because local school boards are ultimately legally responsible for the results. And again, I'm not trying to say that you have to change everything you're doing and suddenly take all the control back. There are administrative functions that are uniquely where the administration is uniquely qualified to handle. But they do not run the schools. The local school boards do. So we have some new needs assessment amendments. Let's see if yeah, okay. The legislature has added quite a bit of teeth to the needs assessment law by requiring, when you have school board meetings, that the minutes of your school board meetings reflect that not only did you have those assessments that you are in control of conducting, but that the board evaluated those assessments and indicated how the board used such assessments in the approval of the school budget. And I can tell you that some of the minutes that we've seen since the passage of the law are woefully inadequate in terms of demonstrating how the local board used the assessments in the approval of the school budget. This is where board members need to ask questions and expect answers. In addition, the law now requires that every school year, the local board must review the state assessment results. And these are not the needs assessments. These are the state assessments that you look at, and that's a primary function of your job. And document the barriers that must be overcome to have all students achieve proficiency above level 2 for grade level academic expectations. B, any budget actions, including possible reallocation of resources that should be taken to address and remove the barriers. And C, the amount of time the board estimates it will take all students to achieve proficiency above level 2 if such budget actions are taken. This is a call to action to not let class after class after class matriculate through, be socially advanced to the next grade without there being adjustments to the budget to address the particular needs of these students that are falling behind. The statute now mandates that the school district budget approved by the board, quote, shall allocate sufficient monies in a manner reasonably calculated such that all students may achieve the goals set forth in 723218, again, the Rose standards. This is a direct quote from the Gannon decision, indicating what the court's mandate is that the structure and implementation of school funding be reasonably calculated such that all students may attain the goals set forth. And as I mentioned earlier, the allocation, the implementation of this funding is your responsibility. A review of needs assessments and board amendments since these legislative amendments still reflects a misreading and unfortunately an intentional disregard for the statute's requirements. For example, there are still references in some of them that we've looked at to lack of funding as a barrier. That is not a barrier. The court has already ruled that school funding is adequate, that schools are getting adequate funding. And yet we still hear the same mantra of, well, if we just had more money, we could do better. The districts have had adequate money for, the last time there was a cut in school and base state aid was 2009, and that was during a recession. Funding has set records ever since. And there's also clear evidence, if you look at the KSDE website, that the local boards are seen as only having the function of approving the USD official state assessment review without having actually conducted the needs assessments. And so the KSDE has really taken it upon itself to say, hey, local board, this is our responsibility. We'll take care of the needs assessments. We'll put together an official document and we'll hand it to you at a meeting, and we want you to okay it. I'm sorry, but that's not how it works. That's not how the statute is worded. If you care to read the statute, and by all means, ask questions. Kansas public schools are fully funded. The problem is allocation of those resources, and the allocation of those resources and the approval of a budget that addresses the needs of every student is a responsibility of the local board. So I hope everybody by now is aware of the KSDE accounting handbook for USDs. This is actually an important document because it provides for a uniform method of accounting for receipts and expenditures, such that all districts are basically operating in the same atmosphere in terms of their accounting principles. Account code 1000 is instruction, and there is a definition there of instruction. It is very broad. But if you read that accounting handbook, there's one of the most powerful messages about the importance of instruction that anybody could possibly come up with. Quote, although all other functions are important, this function, instruction, acts as the most important part of the education program, the very foundation on which everything else is built. If this function fails to perform at the needed level, the whole education program is doomed to failure, regardless of how well other functions perform. Can you imagine a stronger message than the education program is doomed to failure, regardless of how well other functions perform if you don't get instruction right? This statement, coupled with the needs assessment mandate, is the strongest argument that can be made for a budgeting process that is built from the classroom up, not the administration building down. But what does your budget look like? It's the administration building down. That's not what we're seeing in district. We're not seeing in district budgets an emphasis on instruction in the classroom, the needs of the classroom as evidenced by the building-based needs assessments, and then everything else flows from that. The accounting handbook says you really need to start with instruction and build from there, because if you don't get instruction right, every other program is doomed to failure. KSA 725191 was passed in 2005 in the special session right in the middle of the Montoy, State v. Montoy school finance litigation, sets forth the state public policy goal that at least 65% of money appropriated or otherwise provided schools be expended in the classroom or for instruction. That statute remains in effect, 65%. At the time, the actual amount that was being spent on instruction during that litigation was a little over 50%. So I'm going to take just a minute here. Instruction has a broad definition in class code, account code 1000. Activities dealing directly with the interaction between teachers and students and may be provided in the classroom and other locations such as a home or hospital, in other learning situations such as those involving co-curricular activities, may also be provided through the internet, television, radio, computer, multimedia, telephone, correspondence that's delivered inside or outside the classroom and other teacher-student settings or through other approved media. Instruction also includes the activities of aides or classroom assistants of any type, including but not limited to clerks, graders, teaching machines which assist in the educational process. I really can't think of a much broader definition for instruction for accounting purposes, but notwithstanding the broad definition of instruction, financial reporting that the legislature has mandated has demonstrated that even in the face of years and years of underperformance, school districts aren't even coming close to meeting the statutory policy goal of 65% funding to the classroom or for instruction. In fact, the actual percent of funding for it instruction hovers around 50%. It's actually a lower percent now than it was during school finance litigation when in 2005 the 65% policy goal was put in place. So let's look at what the consequence of that has been over the years. Since 2005, there hasn't been 1 year where the 65% goal was close to being met. The cumulative loss of funds to the classroom and instruction by not meeting the goal established by the legislature and the governor in 2005 has been $12.2 billion and counting. Now, keep in mind, this is money that the legislature appropriated for schools. Schools got this money. It was intended to be used for instruction, but was spent elsewhere, based on district budgets approved by local school boards. If student performance is to improve and improve it must, it's up to the local boards to make that happen. That number, incidentally, is an average of over $600 million per year that the policy has been in place. $600 million a year of money the legislature, and I would argue the students and the parents expected to go for instruction went somewhere else. So let's talk about the at-risk students in particular, because that's why we're here tonight. And while the Montoy and Gannon school finance cases sought additional funding for all schools, that was the plaintiff's argument. The Kansas Supreme Court correctly, I might say, stressed the need to target the an alarming number of students who are being left behind academically. They estimated that to be in the 25% to 33% range based upon the data that they had at the time. And those were poor kids, racial minorities, socioeconomically challenged, what have you. Those who are identified as at risk of failing to achieve the benefits of educational improvement in the Kansas public school system. And keep in mind, the promise of education in the Kansas constitutional article is a promise to all students, not just the A students or the B students or the C students, or the ones that really don't have any challenges or barriers. Every student in the state has this promise through the Constitution and through statute. Now that schools have been fully funded for over 15 years, as I mentioned, the last cut was in 2009, student outcomes are reflected that this population of at-risk students has not benefited. It did not benefit from the billions of new dollars that was spent. And in fact, in many ways, the student performance has declined over time rather than improved. They've been stagnant despite substantial increases in funding. And that's proof positive that it's not how much is spent, but rather how funds are spent that is important. And again, the implementation, the allocation of those resources is uniquely a function of local school boards. So here's really where I get fired up. We have a legislative division of post audit, which are some of the best auditors in the country by reputation. And I mean that honestly. They have great credentials and perform audit functions all across the government spectrum multiple times a year. Specifically, in 2018 and 19 school year, the state provided over $400 million in dedicated funding for districts to deliver services to students that were at risk. So LPA, I refer to the legislative post audit as LPA, conducted an audit of a number of school districts that had received 125 million of that over 400 million to determine how the funds were being used. LPA found that most funds were being used for teachers and programs for all students and didn't appear to specifically address at-risk students as required by law. In addition, most of the at-risk programs and practices reviewed lacked strong research that they were even effective. LPA found that the Kansas department had not approved strong at-risk programs or provided good guidance to the districts. Most programs were not evidence-based, and most of the at-risk practices approved by the state board didn't target at-risk students. Well, you would think maybe that audit would get somebody's attention. It really didn't, unfortunately, and I'm sorry to say that. And again, I hope you don't shoot the messenger. A follow-up post-audit released in July of 2023, just last year, reported that state law required that districts spend money for their at-risk funds only on programs approved by the state board. Post-audit was told by the department that the state board had delegated the task of approving at-risk programs to the department. None, I repeat, none of the programs reviewed by LPA met the statutory criteria necessary to be included on the approved list of at-risk programs. Most had little to no evidence of effectiveness. Most did not appear to meet the purpose of providing above and beyond opportunities to at-risk students. They found that the department did not follow its own process and that the state board did not provide any oversight of the department. Like the earlier audit, LPA found districts were still not spending at-risk funds appropriately. Nearly 30% of the funds in this audit did not comply with the law. LPA found that over the past 6 years, all 3 at-risk cohort groups they evaluated performed worse, not better, over time. Graduation rates and ACT scores were lower as well. The legislature really is tired of these failures, and they rely heavily on these audits. It's like Reagan: trust but verify, hope for the best, plan for the worst. Frustrated by these audits, the legislature has doubled down on the law's requirements. So they passed in this past session, 2024, an at-risk student accountability plan. So it's a 10-district pilot program for school year 24-25 within all school districts coming in line 26-27 that requires local boards to annually submit to the state board an at-risk student accountability plan to attain at-risk student proficiency and to ensure the provisions of programs and services that are above and beyond regular educational services. It's kind of like, well, we put in statute what we meant. Now we're going to tell you we really mean it. The purpose of these plans is to show that the districts are using evidence-based instruction as defined in the statute, measure longitudinal academic improvement, and I think everybody here knows what longitudinal academic improvement means. Although there was a meeting of the state board where there was some question as to what longitudinal even meant. We need to not only concentrate on what this 3rd grade class is doing, and then the next 3rd grade class is doing, and the next 3rd grade class is doing, but look at what this 3rd grade class is doing in 4th grade. How are they then doing in 5th grade? That's longitudinal. And we are woefully inadequate in actually tracking these students to make sure their individualized plans of instruction are being fulfilled, rather than just moving these kids along where their math skills, their reading skills, their other outcomes are not adequate. Another point is to establish quantitative student academic goals for these students, ensure at-risk funds are expended in accordance with law, and continue the process of identifying cohort groups of at-risk students and providing evidence-based instruction above and beyond that of regular education students until the district meets the state board's goal of 75% of all students achieving proficiency at level 3 or 4 on English language arts and math assessments. Now, I think that's fine, but the corollary of that is we're missing 25%, aren't we? We're still, I hope no one thinks that 25% in levels 1 and 2 over time is a good thing. Because remember, the promise to these students is that we're going to get you all proficient. We're going to get you all to have some level of postgraduate success, and not just a menial minimum wage job, but the job you really wanted, that you aspired for, that you have the academic aptitude for, but that you're not getting the adequate services that you need to get you where you need to be. So every time I kind of put an asterisk every time I see that 75%, because I don't want anybody to forget the 25%. And unfortunately, I think that 25% is being forgotten. The statute goes on to require the districts to identify no less than 2 cohort groups to track, one grade 3 and another in any grade K through 8. One must consist of free lunch students, and one must be made up of at-risk students or one of the subset groups identified for state assessment purposes. And then each district is to establish a 4-year quantitative academic improvement goal for English language arts and math for each cohort group, and repeat that process every 4 years. In order to provide adequate longitudinal tracking, the district must not revise its goal for that period. we've seen too many times over the years, the goalposts keep moving. So we have a heck of a time tracking longitudinally. And we don't know whether that's because somebody thinks that there's a better mousetrap or they really don't want the tracking because the tracking outcomes don't look good. I hope it's not the latter, but the statute says, keep the tracking the same. The district must identify and implement 2 to 4 targeted supports or interventions contained on the board's list, state board's list of approved at-risk educational programs to provide evidence-based instruction that is above and beyond regular educational services. This is not using at-risk funds just in the general gen ed classroom where at-risk students are mixed with everybody else. These are additional programs that go above and beyond because these kids have barriers that other kids don't have, and we need to address those. And you're to evaluate whether they have a positive impact. And if they don't, they can be replaced if the district finds any to be ineffective. Here's the rub. For the first time ever, there are consequences. Commencing in 2030 to 2031, that school year, if a cohort group doesn't meet or exceed goals, the state board is required to deem the district as not meeting at-risk improvement requirements and must post it on the state board's website. A cohort group not meeting goals is kind of like double secret probation. A cohort group not meeting goals will have an additional year to meet or exceed the goal. If after that year the goal has yet to be met, at-risk and high-density at-risk funding is reduced. There's a funding consequence. There are greater funding consequences if both cohort groups fail to meet this goal during that period. And then there are a number of reporting requirements included. And that may sound tough, but for crying out loud, this is 2030 to 2031. If I'd have been doing this, the consequences would have started sooner than that. And I know that there was some angst over the fact that, oh my gosh, there's going to be some financial consequences. I would invite anybody to look at the state Kansas administrative regulations for the State Board of Education on accreditation. The state board regs, even though they have never not accredited a school district, have financial consequences for lack of accreditation. So it's not just the legislature, but it's also the state board that says at some point there have to be consequences if we're not getting the job done. In addition to that accountability plan, the legislature also made some other amendments to the at-risk law. Again, kind of belt and suspenders. They amended the law again to make it clear that funds may only be used, at-risk funds can only be used on at-risk and provisional at-risk programs that are provided above and beyond regular educational services to students who are identified as at risk. This really goes without saying, but the reason they had to do that was because of those 2 successive legislative post audits that said that the districts that were audited are apparently ignoring that law or have not read it thoroughly and are not complying. Language was added requiring the state board to identify, approve, and provide a list of at-risk programs that provide best practices and evidence-based instruction. Now, this was a requirement in original law, but the LPA found that the list contained many programs that didn't qualify. The state board is currently working on an updated list, but a preliminary list that we've seen still shows programs that are suspect and inadequate. The state board is required to update the list, but there was a prior reference in the statute being tied to the board's 5-year accreditation system. And that's repealed because the board didn't have 5 years of evidence-based and research on these programs. And so that 5-year process really is not necessary, and that's been repealed. The law, approved programs must be demonstrated to have shown improvement year to year, not over a 5-year period. The law makes it clear that no expenditure shall be made from a district's at-risk fund for any program or service not found on the approved list unless it's for an approved provisional at-risk program. And above and beyond is further defined to mean an at-risk educational program or evidence-based instruction and practices provided in excess of regular educational services and based on the needs of students identified as eligible to receive at-risk educational programs and services, and may provide a collateral benefit to students who are not so identified without any additional cost. I hope everybody is aware of the definition provisional. If it's not on the list, but a school district is convinced that they have a whiz-bang at-risk program that is working for them, they can apply to the state board to have that approved as a provisional program. But it's got to work. And here, the local boards, if you're going to approve one, really make sure that it's well researched, it's evidence based, it's peer reviewed. It's not just some website that somebody came up with, or one person wrote an article and said, I think this is a great program. This really has to be academically, you need to be intellectually honest about these programs, because these kids deserve it. The state board's list, based on department input, included in some cases mere links to educational articles. They weren't peer reviewed or evidence based. The list didn't provide any meaningful guidance to the districts and their teachers on what the programs were, whether they were in fact effective. The board's current project of reviewing programs has reduced the list from around 270 to around 150. The list needs to be much smaller. In fact, I would suggest a list that has 50 might even be too much. There are some good programs out there, but districts become overwhelmed. And we listened in on one of the recent school board meetings where the commissioner said, well, we put this list together, but we're not going to give any endorsements. We're not going to make any suggestions. Here's the list. That's what we're required to do. Here's the list, and good luck with the local school districts to choose wisely. And I'm critical of that, because I think one of the things the districts want, they want to have some guidance. They want somebody to have reviewed these programs thoroughly. Guess how many people they have working on this project? One person has been delegated the task of coming up with these programs. It's no wonder that they're not planning on providing any guidance or suggestions to the districts. In fact, if you look on the website for the evidence-based programs and practices, it's the same list as before, and the ones they've eliminated, they just draw a line through. I mean, it hasn't even been reformulated. Now, I realize, in all fairness to the state board, they're not finished, and I encourage them to keep drilling down on these programs and give the local school districts credible programs, maybe not 150, but ones that are really evidence-based and peer-reviewed. You guys are needing much better guidance, and I think the districts are asking for it, and if they're not, they should be. While no school district in Kansas has ever lost its accreditation status, state board regs require as a condition of accreditation that a district be in good standing. Well, when you look at that regulation, there's actually a definition of in good standing. Means, quote, in compliance with or working with the state board to achieve compliance with all applicable federal and state statutes and regulations. Yet, legislative post-audit has already identified a number of districts that are just not following the law. And that's just one statute. That's just one requirement that the legislature has made. KSA 725170 required the state board to adopt a school district accreditation system based on improvement in performance and is measurable. And we are frankly seeing a lot of school districts that are not making improvement in performance. And there is very little, what is measurable is we're seeing the assessment results, ACTs, we have all sorts of data. So there are some measurements. but we're not seeing much in the way of improvement. Now, we know the state board is working on state accreditation, and it really does need to be meaningful. The legislature intended it to be based on improvement and measurable. And I can tell you, just like the at-risk frustration, the legislature is running out of patience on the accreditation system. You can probably look for enforcement measures to be proposed unless the state board's new accreditation model that is in the works is found to be acceptable. So as far back as 2005, during school finance litigation, the court, as I mentioned earlier, identified the 25% to 33% of students who are at risk. That percentage has actually grown despite the infusion of billions of new dollars. So David Dorsey, a former teacher writing for the Kansas Policy Institute, has done a lot of research in this area. Estimates that in 2015, there were 53,737 students reading below grade level. That number is now north of 82,000. In fact, I've seen a number closer to 85,000. And this only accounts for students tested in grades 3 through 8 and grade 10. So that actual number is probably a lot higher. He notes that the likelihood that those students will be able to earn an industry certificate or some other post-secondary education is pretty low. These kids won't be able to achieve their true potential thanks to an education system that has failed to meet their needs. Those kids are more than numbers. And this is probably my biggest pet peeve. Anytime, and I served in the legislature, was very much involved in education. Meeting after meeting after meeting, all I heard were numbers. I never heard anybody really appear before the committee and put a face to K-12 education. These kids are more than numbers. They're flesh and blood. They have names. They have hopes and dreams, and they're deserving of a public school system that provides the educational services they need to succeed. So when we think about this 25%, or we think of, hey, we've got 75% that are in level 3 or 4, think of the kids, the actual kids, the boys and girls in the 25%, we'll call it. They're there. They go to school every day. They may not have the best family life, but that is the responsibility of the public education system. Don't leave any of those kids behind. And yet, time and time again, we see the education community patting itself on the back for all the kids that they have in level 3 and 4. And we keep saying, but what are you doing about levels 1 and 2? I was at a committee meeting where a representative, a lobbyist for the administrators organization, claimed that they can't get level 1 kids to level 2. That's criminal. I mean, that is so sad that you would have somebody invested in the education establishment getting just blatantly tossing those level 1 kids aside. The promise of public education in Kansas is that every child has that opportunity. It is the expectation of the court that ordered a lot of money that the public school system use that money to get those kids proficient. And yet we've seen, particularly with the failure to meet the 65% goal, that it's just not happening. And no one seems to be too concerned about it except us. I even get emotional thinking about those kids that just get passed along year after year. And we're not using the funds appropriately to get to them. And so this is really, it's a call to action for local board members. It's kind of like Star Wars. Help us, local board. You're our only hope. Ask the questions, really drill into those budgets, make sure that those budgets are built from the classroom up. And if they need to be reallocated, the statute now says if you need to reallocate. And I know the administration will say, oh no, these numbers are really, these are solid numbers. We really need you to approve this budget item. Keep in mind those kids, names and faces who are in level 1 and low level 2, that we now call it low level 2 and high level 2, according to the state board, or according to the department. Think about those kids when you're doing those budgets. Ask the questions, expect good answers. Make sure those programs that they're getting are actually worthwhile. And with that, I'd be happy to answer any questions that participants may have.
Well, I have a basic question, so kind of a pragmatic, some advice, I guess. So when a board, you were talking about a board needs to ask some of those questions. What some of us have seen is that oftentimes boards are given a budget. Here's the budget, here are the numbers, pass it, rubber stamp it, go through. What kinds of things should a board member ask when they're thinking about this coming down the road? They're thinking about this at-risk funding. They feel passionately about it. They know that's what they're there for, is to hold that accountable. What kinds of questions do you think that they should ask in order to be able to get at this, to understand how this at-risk funding is being spent in their districts?
Yeah, good question. And I think that at the latest, that discussion begins when you start doing the building-based needs assessments. Because keep in mind that law says you do that first, you review those assessments, and then the budget must take into account what those assessments suggest. And so the questions really begin at the building-based needs assessment stage. Whether the board is intimately involved in conducting that, or they're following along as those assessments are being prepared at the school level, and ask those questions. And if they're getting fluff, like what are the barriers? And the barriers, well, if we just had more money, we could do this. That's not an adequate answer. And so that's when the board needs to say, oh, stop right there. That's not a barrier. We're talking about the kids that have barriers to that they're at risk of not graduating. And now you're armed with some information about how we have under allocated on instruction. And I think the budget needs to, you need to be armed with that data. You need to be armed with your assessments, not the building needs assessments, but actually the student assessments and that material, and be asking the school district, what are your plans for moving the dial on these students? Not just, well, we want to have more that go from level 2 to level 3. And the last report is going that you hear from the state board is going to say that the department gave the state board is that, well, we made some improvement there and that we ought to be having a party. And the improvement was minuscule, and it totally ignored those kids in level 1, and we'll call it low level 2. And so I just encourage boards to really make the district focus on those students, because that's really the prime responsibility. The other students that are doing fine, the district must be doing something right to have all these kids in level 3 and 4. Fine. The promise of education, though, is all students meet the Rose goals. And what is the district? What are your plans, district, to get these kids up there? And in fact, the statute, as I read the 3 things that must be reflected, and how many years is it going to take you? If we beef up money in instruction, what are you going to do? How long is it going to take for these assessments to improve? And expect an answer, and not just a pie in the sky guess. Because if it's going to take longer than 2 or 3 years, then more money needs to be of the budget, that the money that you have available. Some other priority is going to have to take a back seat to getting more money to these kids to lift them up, because that's what must happen. I know it's a long answer to a short question, but It starts with really paying attention to those building needs assessments, because those should inform local school board members as to what their budget ought to look like. And if the budget doesn't look like that, and it looks like, frankly, a lot of them we've seen just ignores the building-based needs assessments and says, well, this is, this was our budget last year, and we need a little bit more in this category, a little bit more in that category, and the categories don't really change much. My poster child, and again, with all due respect, with all apologies and due respect to those who work hard on these budgets, is, do you really need that fifth Suburban? I mean, do we really need to replace, all these vehicles every 3 years instead of 4? So much money is being siphoned off of the instruction and classroom that it's heartbreaking. And that's where I think the local boards really need to lean in and make sure that we're making a difference for those level 1s and level 2s.
Well, I think you made a really great point when you were talking about how, there's this standard or this expectation, 65% of the funding should go to the classroom, and we're not even meeting 50% of that. So if you have all this at-risk funding that's going to the schools, as you pointed out, so it's somewhere in there. And so it sounds like it's up to the local school board to be asking those questions and say, bring me the data on the at-risk funding, bring me those reports on the assessments and those cohorts as they're moving through in those longitudinal studies.
Yeah, and I just thought of something that bears repeating. You can spend all kinds of money on at-risk. You have an at-risk funding allotment. It doesn't have to end with spending the last dollar. The 65% in the classroom applies to everyone. Mm-hmm. And by everyone, it also applies to your at-risk students. So you can spend a lot more on at-risk students that are identified as at-risk than you actually receive in the at-risk weighting. And I hope there's no misunderstanding about that. We've actually had the opposite problem, where the at-risk dollars that you do have are being spent on general classroom, when the opposite should happen. All the at-risk funding that you get should be spent on at-risk students, and probably even more, in general education. So that helps everybody in those classrooms. And the largest component, I know this is getting into controversy, the largest component of account code 1000 are teacher salaries.
Right.
We are seeing an alarming percentage increase in administrative salaries and non-instructional personnel hirings, and teachers are being left behind. The very people that we need to get these kids proficient. And they need good advice on curriculum. They need good advice on what at-risk programs they are, and they need to be compensated fairly. And frankly, we're alarmed that the only good job in education right now is administrative. Gosh, why would anybody go into teaching when they're capitated on what they can make, and administrators apparently aren't? So again, with all apologies to administrators, we've kind of got this formula flipped upside down.
Well, you make an excellent point, and particularly about how this at-risk funding should be above and beyond. So we're talking about the 65%, just as you pointed out so well, that's not like the ceiling. That's the general instruction, and then at-risk funding goes above and beyond, correct?
Correct.
So then my question is, in 2031, if a school has shown that they have not used their at-risk funding as was allotted to them within those boundaries of the statutes, and it's then removed, they're still obligated, is this correct, that they're still obligated to provide that at-risk education to increase those assessment scores? Is that correct?
Yes, and keep in mind the penalty doesn't kick in if they've failed 1 year.
Right.
If they fail for 1 year, it just goes up on a website. And if people want to look at it and say, hey, my school district's on probation, so to speak, it's meant to provide pressure because apparently the statutes aren't aren't strong enough. I mean, nobody feels like there's going to be a consequence if they ignore the statute. They might have even had people come in, administrators or superintendents come in and campaign against the passage of the legislation. I've heard a member on the state board say if they don't like what the legislature has passed and they feel like they're not in their lane, we'll just ignore it. I mean, this is what we're dealing with.
Mike, Tracy, I need to comment on this. The state test results just got assessment results from last year just got posted. They're on our website. I've been asked daily by school board members, where do you get our test results? That's a joke. Every superintendent should be providing them the minute that they come out so they can start the needs assessment process. And then I was talking to two guys today, and they knew we were having this tonight, and they don't even know the kids, how they identify the at-risk kids in their district. And I don't know if that's listed anywhere for a school board member. Like, how do you actually identify an at-risk student other than free lunch? Is there an answer to that?
Yeah, and actually, those are two separate items. The proxy for funding at risk, in other words, the formula for how much a district gets is how many free lunch students that they have. Because there's got to be a uniform way of determining what the funding is. Having said that, the school district gets to determine on its own who's at risk. They know who they are. And there's actually, I don't have it right in front of me, but there's actually a statute that has 6 or 7 different items that can be looked at. And in fact, we are in the process of putting together a set of statutes, publication of statutes that of interest to school board members, and that will be in there. But you're absolutely right. They need to know how they're being identified. And again, it's a very broad, it's very broad because the challenges are not all socioeconomic.
But I would say for school board members, one, you have to identify them. And then 2, you have to know which one of those state board of education programs that are approved you are actually using. And I bet I've talked to 20 school board members in the last 2 weeks, could not tell you what they're using. And that's something that I think they're responsible for.
Yeah, and again, not to shock anybody, but we talked about 20 years of litigation where the defendant was the state of Kansas. What I'm concerned about moving forward is we have a situation in Kansas in Brown versus Board of Education. What was at stake there was getting away from separate but equal, where we had racial segregation.
Right.
But Kansas was one of the states where their separate part of their education was actually comparable to what white students were getting. The problem is that there was racial segregation. I would argue right now, we have unified school districts, so integrated school districts, where the education is anything but equal. We have socioeconomic challenged kids. We have minority students who are locked into underperforming districts by virtue of their zip code. And in those districts, it's even more important that the local boards make darn sure that those kids are getting the services that they need. So it's not essentially a Brown versus Board situation. And sooner or later, there are going to be some litigation, and it's not going to be against the state. It's going to be against local school districts.
Well, I have a question from one of our attendees that says that they're trying a new program this year. But it's not on the list, not on the approved list. I know you've covered this, but they said that the data looks really good on the program. It's their first year, but the funds from the at-risk, can they be used for that if it's not on the list? I think you talked about that again, but if you wouldn't mind just briefly reiterating that, that'd be great.
Yeah, there is a procedure for having the local school district apply to the state board to get a provisional program accepted. And then you'll have to show results after that first year. So if you identify a program, you're convinced that it's a good program, make application to the board, and the department should be able to help you with that. They maybe even have a form. And again, I'm sorry I don't have that right in front of me, but there is a process for getting that provisional at-risk program approved.
Great, thank you. Well, we are really right close to our time. We're right at our time, and so we don't have any more questions. But thank you so much, Mike, for coming here, talking about this important information with us again. I know that this is a passion of yours, and we appreciate that, you bringing this to us to ensure that school board members understand their responsibility, and that everyone is able to have all the information that they need. So want to let everyone know our next webinar will be November 13th. That webinar will be an update on the Blue Ribbon Task Force on student screen time. We'll have 2 panelists who are on that Blue Ribbon Task Force to bring you information. They will not make recommendations, but what they'll do is they'll tell you a little bit about what they've been hearing as they've sat on that Blue Ribbon Task Force, as you all start to make some decisions as to whether you want to move ahead with a policy for your district or whether you don't want to do that, but that'll bring you up to date on that. And then after the holidays in January, we will have a highlight of a program that I talked about at KSBRC second annual meeting, and that is the Compass Academy Network. A date has not yet been set for that, so just keep your eyes open for that. We'll send that out. So this Compass Academy Network is a free summer enrichment program for 6th through 9th graders and has been proven student academic assessment scores to improve through these critically important years when students' scores typically will decline in a lot of different districts. So that's what we have coming up. And just look for the link and the recording of this webinar. And if Mike or Ward doesn't have anything else, then we will dismiss everyone and hope everyone continues to have a really great evening.
Good night. Look at your building's
Thank
needs
you.
assessments. Good job.